Are you going to have your witness testify, sir?
No, Judge, I wasn't planning on calling any witnesses. I was just going to ask that you take judicial notice of the court's file, and the clerk's file.
All right. And then I will not need to swear him in, apparently, but he is present for the record. This matter is being broadcast through YouTube because of the requirement for a for proceedings to be public and in open court. So in this matter, the state and defense are in agreement to conduct this by Zoom, especially since the defense has so stated in the title to their motion. Is that correct, sir?
Yes, Your Honor.
Okay, Mr. Holscher. And for the record, present on behalf of the state is Andrew Edelman. I am Judge Longoria. I'm listening to this matter and will attempt to make a decision. Edminia, thank you for helping us today. And of course, Patty, my coordinator, is on board. So where's Michelle? What happened to her?
I'm right here.
Okay, there she is. Thank you, ma'am. Michelle Garcia is our deputy county clerk. Mr. Holscher, this is your motion. You may proceed, sir.
So, Your Honor, briefly to attempt to orient the court because the case is somewhat old. Mr. Tureen was arrested on or about September 13th of 2015. It was sometime later in June of 2016, specifically June 30th, 2016, that we had a suppression hearing in front of yourself. At that hearing, at the beginning of the hearing, there was a standing blood order that had been signed. The state, for the first time, tendered to us blood discovery right before the hearing, but outside the deadline specified in the order. After some discussion about where that blood evidence had been, it had previously been represented as missing. We proceeded to a suppression hearing, but the court excluded the blood in the case. So we just litigated issues related to reasonable suspicion and probable cause of the stop, and then the arrest, as well as some other issues related, such as the presence of the cameraman on the video and some statements and things like that. The primary issue, though, was the reasonable suspicion and probable cause of the underlying offense, the DWI. Before the court could rule on that, the court had advised us that it would seek input of briefs, case law, and was withholding its ruling. The state sought an interlocutory appeal on the issue of the suppression of the blood draw. That went to the fourth court. You were sustained by the fourth court in excluding that evidence. It then was taken to the Texas Court of Criminal Appeals, which declined to hear the petition and came back to the court. All of that delay was on the state's part. Once it came back, we had a transition in district attorney administrations. I came to court and repeatedly requested some settings, but the state was requesting more time because they were unfamiliar with the case. Just briefly, this case involves an 18-wheeler that was driving the wrong way on I-10. However, it exited I-10 and was pulling into a truck stop, and the arresting officer testified he pulled over the first 18-wheeler he saw at that point, based on a limited description of the 18-wheeler from the officers who were following it on 10. We have requested a trial, we've requested suppression, we've requested new hearings, as we are again today. As you're aware, in Texas, 8 months on a DWI is a presumptively unreasonable delay under Barker v. Wingo, which would flip the burden to the state to prove that the delay in this case has not been unreasonable and that it has not been a prejudice to the defendant. So the other three factors that we look at are the length of delay. In this case, we are going on 5 years. As of September of this year, it will be 5 years that this case has been pending, which is extremely long for a DWI, particularly where the defense has been requesting evidence, was having hearings, and you'll see in the court jacket, requesting that we be provided with evidence that was never provided until a deadline had been set. The state violated it and attempted to tender it at a suppression hearing where it was denied. It was the state who took the interlocutory appeal. So all of the delay in this case is really due to the state, and that weighs heavily in favor of dismissal under Barker. Additionally, there were a lot of witnesses to this case, including individuals in the media. And we are no longer able to acquire some of those individuals. We haven't been able to even figure out who all of them may be. This is in part due to the delay in receiving evidence from the state early on in the case. And now, it's stale, and it has been really for years. So there's a real problem on the defense side with us attempting to bring some of the evidence that might be relevant to a defensive trial. But the reality is my client is prejudiced just because he's been on bond for 5 years, going on 5 years, because he's had to go through an appeal. That was additional time and expense on his part. His liberty has been restrained. He is or was a truck driver by profession. But while this case is pending, he's been restrained from his occupation of choice. So
Your
there's
Honor,
a lot of prejudice.
Your Honor, excuse me, Judge.
Hello.
There's a person that's trying to get admitted to the hearing. It doesn't say the name, it just has numbers. I don't know if Joseph is expecting somebody else or Andrew is expecting somebody else.
I am not.
Should I admit him, Judge?
I don't see Mr. Tureen anymore.
Oh, maybe it's him. No, well,
Pardon me?
Should I admit him?
He's not a participant. He's welcome to watch and listen, but as far as I can see.
It could be Mr. Tarin because he's no longer on the screen with us.
Well, let's find out who it is. Bring him in. If it's
Okay.
Mr. Tarin.
Yes.
Is that you, Mr. Tureen?
Yes, sir.
Okay. So, Judge, we think that the prejudice to my client weighs heavily against the state. At this point, we're asking for a dismissal, but it's really the state's burden because of the length of delay. At 5 years, we're approaching something that might be reasonable according to the case law for a complex capital murder, but not for the BWI.
Anything else, Mr. Holscher?
Not at this time.
Mr. Edelman?
Well, first, I'd like to start by saying that Mr. Holscher, I think, is incorrect in the way that he characterizes Barker v. Wingo analysis. Under case law, which Mr. Holscher never cited, when a presumptive delay has elapsed, and in Texas, there is no presumptive time limit of when that is, although there is a range, with 4 being considered too little and 17 being considered quite enough. Then the court moves to an analysis of the Barker v. Wingo factors. And importantly, in the analysis of those factors, no single factor in and of itself is the sine qua non of the court's decision. The factors are considered interrelated, and the justifications or excuses for one reason can affect the balance of the other reasons. For example, if the state has engaged in a particularly egregious attempt to delay proceedings with the aim of improving the state's position, then the corresponding requirement of the defense to show that it has asserted the right and been prejudiced lowers. Conversely, if the reason for the delay is relatively neutral in terms of the state's culpability or is not to be held against the state at all, then the corresponding requirement for the defense to show that it has asserted the right in a timely fashion and been prejudiced rises accordingly. So this is not an analysis in which the burden rests on the state entirely. It is a burden that the state and the defense each need to show for their respective Barker v. Wingo factors, with those analyses being interrelated. Next, I'd like to move on to the fact that Mr. Holscher has not presented any evidence that the court can consider in making its determination. Mr. Holscher has stated somewhat eloquently that he has made diligent efforts to have this case placed on the docket for continued hearings. However, he hasn't, first of all, he's not sworn in, and so his statements are not to be considered evidence. Second of all, he has not stated which prosecutors he has conferred with in an attempt to move this case along. He hasn't stated when he spoke with them. He hasn't produced them to testify. He can't point to any notes in any file that would substantiate or corroborate his claims. Additionally, if you will look at the court's file, which I have, you will see that the last notation is a notation stating that the case was being remanded from the Fourth Court of Appeals following its decision, which cited in favor of your ruling and against the state. And there are no further notations made by anyone concerning any of the negotiations that Mr. Holscher references. Moreover, even if the state wanted additional time to decide whether or not it would proceed, if Mr. Holscher was sincerely intent on bringing this case to a speedy resolution, then the appropriate method was not to wait for the state to make some sort of decision, but to have the court exercise its authority by setting its own cases and force the state to make a decision rather than allowing the state to wait. Although, once again, Mr. Holscher has not produced any evidence that actually substantiates its claim. And so I think the claim should, at this time at least, be ignored. Now, Mr. Holscher characterizes the delay as one that is entirely attributable to the state. I'd like to point to State v. Munoz, and let me get that citation for you. 991 Southwest 2nd 818, in which the court writes—
What is the name of the case?
State v. Munoz, 991 Southwest 2nd 818.
I've got the numbers. I didn't. It was Munoz, M-U-N-O-Z.
Yes, there should probably be a tilde, but there isn't.
I understand. Thank you.
The court writes, delay caused by good faith plea negotiations is not the result of negligence or a deliberate attempt to delay the trial, and thus good faith plea negotiations is a valid reason for trial delay and should not be weighed against the prosecution for federal constitutional speedy trial purposes. Now, the procedural posture of this case is not exactly the same as delay caused by good faith plea negotiations, but I think the court can reason by analogy. When the state pursues valid interlocutory bases of appeal of the court's decisions, that is not considered a deliberate delay for the purpose of improving the state's position and harming the defense. It is an attempt to use the appropriate and proper court procedures in order to adjudicate what are considered contested matters of evidence. That sort of delay, one which is sanctioned by the court system itself and whose scheduling is largely outside of the control of the state, should not be weighed against the prosecution for federal constitutional speedy trial reasons. And by that reasoning, the requirements for the defense to demonstrate that it has properly and timely asserted its right to speedy trial and to produce evidence of prejudice concurrently rises. Now, since Mr. Holscher has not placed into evidence any evidence of the delay, either in terms of the loss of witnesses, in terms of the oppressive pretrial incarceration or oppressive pretrial bond conditions, that the defense has not met its burden of proving prejudice. In addition, since this is the first assertion of the right of speedy trial, rather than the first assertion of trial, I think this case should not be dismissed for the foregoing reasons.
Okay. Anything else, Mr. Holscher?
Yes, Judge. So the case that we're citing for an 8-month delay being presumptively unreasonable is Bosworth. That is 422 Southwest 3rd, 759. The case that we're citing to show that the burden flips to the state once a presumptively unreasonable delay has occurred is Doggett. It's a U.S. Supreme Court case, 505 U.S. at page 530. And I didn't get a ruling, so I'm remiss in that, Your Honor, but I am asking that you take notice of the court's file and its contents. Judicial
Okay,
notice.
now, back up a little bit, Mr. Holscher. You cited the first case was 422.
Southwest 3rd, 759.
And what was the name?
Bosworth?
Bosworth.
Yes, sir.
And the other one, the second one, the U.S. Supreme Court, is at 530, but what was the volume?
It is U.S., 505 U.S.
505, okay.
And I'm
Doggett.
sorry, Mr. Holscher, you're citing Doggett v. U.S. as 505 U.S. 647?
Yes.
Um,
I'm sorry. You know what? I must have gotten that page wrong. Sorry, at 530 or one. The page there would be 652.
that's what I thought. Thank you.
No, thank you, Andrew.
505 U.S. 6 what?
647.
Okay. Okay.
Additionally, Your Honor, we don't have to. Did you take notice of the file, Judge? Let me get a clean ruling on that.
I take notice of the court's file.
So once the presumption of prejudice arises in Green versus State, which is a Texas case, at 760 Southwest 2nd 50. So 760 Southwest 2nd 50. It's up to the government to justify the delay. So I'm not the one who really needs to be putting on evidence here, outside of the fact that we've got almost a 5-year delay. And in fact, excessive delay presumptively compromises reliability of trial in ways that neither party can prove or, for that matter, identify. That's from a case that I've already given you. That's Doggett versus United States. So the problem with a delay like this is that we know there's going to be prejudice. And the delay is such that it's even difficult to identify what's going to go wrong in trial once a case gets old. The U.S. Supreme Court has identified that as a problem. So when you're weighing the 4 Barker factors, I agree with Mr. Eidelman that they need to be weighed together, that not one of them is exclusive But in this case, all of the factors weigh in favor of the defense. We have requested trial. It was all of the delay here is due to the state, with the exception of something I admitted, that when the administration changed and Mr. Gonzalez took over the DA's office, I did agree to give them a little bit of time to get to their act together, really, to understand the case and to do the right thing. So to that extent, there is some delay due to me, but this is the state's case and they've utterly failed to prosecute it or even set it since their interlocutory appeal. And the original delay in this case was due to them not turning over evidence, even after the court ordered them to do so. And then they lost on appeal, saying that you shouldn't have held them responsible for that. So I think there is quite a bit of state's delay here. The prejudice is presumed, and it is the state's burden to give you some evidence to rebut that presumption, which Mr. Eidelman has failed to do.
Your Honor, may I briefly respond?
Let me ask Mr. Holcher some questions first. Mr.
Yes, sir.
Holcher, what is the evidence in reference to, I know there's a presumption of 8 months is a delay that creates a presumption. But where is the evidence that there has been, and I realize calendar-wise, we're looking at 5 years. My question is, of those 5 years, how much, where's the evidence of any of it that adds up to 8 months or a year or 5 years that it would be unjustified? I haven't heard that.
It's just the math, Judge, from the arrest date, which was on or about September 13th, 2015. And that's how we would calculate that delay until today. However, the delay between his arrest and the suppression hearing, which was on June 30th of 2016, is almost there. You know, and once the state took up the interlocutory without even waiting for the court, I mean, to this date, we don't actually have a ruling on the stop because they took an interlocutory on the issue of the blood draw before you even had an opportunity to give us a ruling on the hearing that was held and on that record. You know, that appeal that they took up, I think frivolously and lost, both in the fourth court and then in getting the petition for review rejected by the Court of Criminal Appeals, that was almost a 2-year delay. So we can find 8 months at various stages of the case, but overall delay should be calculated from time of arrest until the time of this motion. And I don't believe this is the first motion we filed either. I think if you look in the court's file, you're gonna see another speedy trial motion from around, I wanna say March or April of this year, right before COVID set in and kind of pushed us back some more.
Okay, well, I have a different impression of the time of the appeal until ruling. To me, is not part of the measure or the ruling or the measuring stick that would be applied on the issue of the delay. That's that has to be considered legally a justifiable delay. Whether I agreed with the basis of the appeal or not, and whether the state won or not, it is still it was a legitimate, in my opinion, it was a legitimate delay, and I don't have a problem with excluding that in the timeline to measure or to use in measuring any kind of delay for purposes of speedy trial. So I exclude that part of it as far in my thinking, in my opinion. But okay, now Mr. Edelman requested opportunity to respond. Mr. Edelman.
The only thing I really wanted to say, sir, was to highlight the ways in which Doggett, which Mr. Holscher cites, is distinguishable from this case. In Doggett, the state in the sense of the federal government caused to issue an indictment of Mr. Doggett but then was not able to arrest him before he left the United States for Panama. And then subsequent to that, the Supreme Court found that the government failed to exercise diligence in apprehending Doggett, such that 8.5 years passed between the time of the issuance of the indictment and the time of Mr. Doggett actually being brought before a court for consideration of his speedy trial hearing. And the reason that is distinguishable is because almost from the moment that Mr. Tarin was arrested, in other words, formally accused of the offense, he has had a charging instrument formally accusing him of the offense, and he has been represented by counsel. So he has had access to the court. He has had notice and knowledge of the offense with which he is accused, and he's had mechanisms for bringing issues to the court's attention and having it rule on them. That is very different from Doggett, in which part of the court's reasoning was that Mr. Doggett was not even capable of contesting the charges because he wasn't even aware that they existed. And because of the considerable lapse in time, and because of the state's lack of diligence in bringing him to the court, bringing him before the court's authority, that the state's delay was of a greater culpability than it might have been if he had been arrested with some reasonable diligence and brought before the court's authority and given counsel. That was the only thing that I wanted to say, Your Honor.
All right.
May I, Judge, briefly?
I'm listening.
So initially, I didn't think that what Mr. Edelman was saying was relevant to this hearing, but there is one aspect of it that is. The proposition that I'm citing Doggett for isn't relevant to that analysis he just gave. But in this case, like in Doggett, the state has failed to do anything to move their case forward since the appeal was referred back to your court. So in that sense, there is delay. There is a failure to prosecute, just like in Doggett. And in Shaw versus State, which is 117 Southwest 3rd, 883, it's clear that we measure the length of delay from the time the defendant is arrested or formally accused until trial. So even if we set aside the appellate time, which I think Shaw would say you should not do, we are well outside of 8 months, and 13 months from arrest to a capital murder trial was considered prima facie unreasonable in Harris v. State, which is 827 Southwest 2nd, 949 at page 956. And we're outside of 13 months, even excluding the appellate delay. So the burden here is on the state to produce some evidence of the reasonableness of this delay under all 4 Barker factors. And Mr. Edelman hasn't produced any evidence.
All right. I want you both to give me a brief. I have concerns that, Mr. Holscher, that you have not submitted evidence per se, but you do raise an obvious issue on the length of delay. But at the same time, I'm concerned that a lot of that time has been excluded by appropriate legal appeal. Again, I do not include any of my personal opinion because it was an appeal of my ruling. However, bottom line is, I don't believe that the delay, that portion of the delay is attributable for purposes of speedy trial. However, again, you cite a couple of cases or several cases that are important, and there are some open gaps. Now, you have to distinguish between court delays, in my opinion, the court delay in bringing this court forward, the case forward, and the delay that is attributable, in my impression, to the state itself. If the court delayed cases for judicial time clock, for lack of a better word, I don't think that's attributable to the lack of speedy trial. It's just a matter of the court's availability. So give me a quick brief of the cases that y'all cited. I don't want 10 pages each, but give me that. Can you do that within a week, Mr. Holscher?
Yes, Your Honor.
And Mr. Edelman, I'm sure you can.
Yes, sir.
All right. Get me a quick brief within 1 week, and I'll try to give you a ruling 2 or 3 days thereafter.
And Judge, before we let you go, I would be remiss in not asking or reminding the court that we never did actually get a ruling on the original hearing to exclude evidence. That is on the stop. I know that's old. We may need to review the transcript of that hearing.
Mr. Holscher, I thought that was precisely, I ruled to exclude the evidence for violation of the court's specific order. And that was taken by interlocutory appeal. They appealed that portion of it.
Correct.
That was what the appeal was. So I beg to differ. I did rule, and they specifically did an interlocutory appeal on that ruling.
Yes, Judge, but that was raised as a preliminary issue at that hearing, because when we were coming for the motion to suppress, I asked, do I need to address the blood draw, or is that excluded because they violated the order? Once the court ruled that it was excluded, we then proceeded with the suppression hearing related to the stop. You asked for briefs, and then they filed their interlocutory, and it went to the fourth court before we could actually meet that deadline.
I see. I hear what you're saying.
Yeah. I know it's weird. This is a weird posture for a case, but I haven't actually got a ruling on my motion to suppress that was heard.
Right.
We spent, I think, an entire Friday afternoon on that.
We're going to have to track down or get a transcript on it then. Because I remember that I had suppressed that portion of the evidence. If I remember correctly, I had not suppressed the entire matter. I specifically suppressed the evidence because it directly violated an order of the court in reference to the discovery. So the state is not going to be able to, even if we go to trial tomorrow, the state would not have that portion of the evidence to offer into before the trier of the facts. So do you have before you the date of the hearing?
The date of the hearing was June 30th, 2016, I believe. Or I'm sorry, Judge. You know what? I have given you a bad date. This is on me. That was our first suppression hearing, was June 30th, 2016. The actual motion to suppress was heard March 10th of 2017. So the delay to the actual suppression hearing and the first mention of the existence of blood evidence after they told us it was lost should be calculated between September 13th, 2015 and March 10th, 2017.
Yes, and on there, Judge, on the jacket, you wrote motion to suppress. Court suppresses the blood evidence for reasons stated.
Yeah.
That's written on the jacket.
I ruled only on the blood. I excluded it.
Correct. So,
but Mr. Holscher does have a valid point that there was never on a definitive motion in general or motion to suppress the entire arrest.
Okay.
That was not determined. All right. Give me the briefs and I will, let's see if we can, Patty, let's see if we can't track down who would have had the who could produce a transcript on that?
Probably gonna be Lachey.
Sounds like it. Alrighty.
And you want the briefs by Friday, Your Honor? Say noon?
If you can. Now, if you guys have trouble with that, we have exigent circumstances all around us. If you can't do it by Friday, just let me know. It shouldn't be that difficult. You already got your case law that you cited. But for right now, the date is Friday. Not
Yes,
this
sir.
Friday. I'm sorry, not this Friday. We're talking about, that's a little too quick. A week from this Friday.
It's August 7th.
All right.
Yes,
Thank
sir.
you, Your Honor. Thanks, everybody, for your time today. Have a good one and stay safe.
You guys take care and stay safe. Mr. Holscher, Mr. Tarin. I think I may have asked you before, Mr. Tarin, do you have relatives in Elmendorf?
No, sir, not that I know of. But yeah,
Okay.
you did ask me. I remember that.
Yeah, okay. No problem. It's just that's where I was born and always